esta Real de Jurisprudencia y Legislación. Quiero disculpar a su presidenta, nuestra querida Ana Fernández-Tresguerres, que por razones médicas no nos puede acompañar hoy, como le hubiera encantado. Bueno, hemos elegido un tema que nos evoca lo que hemos vivido estos últimos días en Madrid y todavía en España. La inolvidable e histórica visita del Papa León XIV, visita apostólica que nos ha llenado de energía y nos ha reforzado a los que somos católicos con sus mensajes de fe, de esperanza y de caridad. En este contexto, y cuando el Papa todavía está entre nosotros, ahora en Barcelona, hemos querido unirnos a él en esta sesión y vamos a analizar en ella algunos de los retos jurídicos que plantea la inteligencia artificial y en general las nuevas tecnologías sobre los que el Papa reflexiona en su primera encíclica, Magnifica, Humanitas. Para ello contamos con dos ponentes, grandes conocedores de la materia, a quienes agradezco muchísimo que participen en esta sesión. El profesor Scott Saphiro, licenciado y doctor en Filosofía por la Universidad de Columbia y doctor en Jurisprudencia por la Facultad de Derecho de la Universidad de Yale, en la que actualmente es profesor de Derecho y de Filosofía. Tiene además, creo, formación informática, lo cual, para hablar de la IA, es bastante importante. Su investigación en Filosofía del Derecho, en Derecho Internacional, en Derecho Penal, en Ciberseguridad, en Inteligencia Artificial, ha dado lugar a muchas publicaciones, entre otras Legality, The Internationalists y Fancy Beer Goes Fishing. A mi derecha, el profesor Diego Agulló, compañero, profesor propio adjunto de la Universidad Pontificia de Comillas, donde yo también he sido durante 41 años profesora. En ella se doctoró y ejerce sus tareas de docencia, investigación y gestión. Ha tenido una larga trayectoria internacional. Fue investigador predoctoral en el Instituto Max Planck de Luxemburgo para el Derecho Procesal Internacional, en la Universidad McGill de Montreal, investigador postdoctoral en el Max Planck de Derecho Internacional Privado y Comparado en Hamburgo, y también en la Universidad de Columbia y en la Universidad de Yale. Recibió el premio de la Real Academia de Doctores de España a la mejor tesis doctoral en Derecho y sus principales líneas de investigación incluyen el litigio internacional, las acciones colectivas en el derecho internacional de las inversiones, el arbitraje internacional y el derecho de la nacionalidad. Estos dos profesores debatirán hoy en inglés, en esta sesión híbrida, presencial y online, sobre la ética y la inteligencia artificial en la doctrina de la encíclica Magnifica Humanitas. Allow me a brief introduction to the encyclical of Pope Leo XIV, in which he naturally addresses many theological and pastoral aspects related basically to the Church's social doctrine, but also to different questions in which this doctrine applies to some of the legal changes posed by the artificial intelligence we will debate in this seminar. The Pope justifies the legitimacy and authority of the Catholic Church to speak out on this kind of issues. The Church actively participates in the process by which society grows and is organized and offers her own contribution. Pope Francis emphasized that no one can demand that religion should be relegated to personal life without influence on societal and national life, without concern for the soundness of civil institutions, without the right to offer an opinion on events affecting society. In this session, we will talk about some questions proposed in the encyclical related to international law, ethics, and private international law. Firstly, I will address some questions to Professor Saphiro. Pope Leo states, "It is not possible to provide a single and comprehensive definition of AI. Scott, what is actually AY?
First of all, thank you so much for inviting me to be in this beautiful, beautiful building and to see everyone in the audience. So, funny story. Before ChatGPT came out in November 2022, people had been saying in the United States that China was so ahead of the United States in AI. Then all of a sudden, ChatGPT came out, and then the story flipped, and that the United States is so much far ahead of China in AI. And what you realized was that the definition of AI changed. Before, AI meant facial recognition, gait analysis, things having to do with surveillance. After ChatGPT came out, then all AI became what is known as generative AI, where you have large language models that can write poems and essays and maybe legal briefs, and large vision models that were able to produce pictures and videos. And so what you see is the question about AI is intimately linked with power. To what extent is AI powerful? Or I should put it this way, to what extent, to the extent that a technology is considered to be extremely powerful, we now call that AI. But to back up, so the standard definition of AI is something like the field of computer science or the tools that enable digital devices to do things that would normally require human intelligence. So like things like decision making, language, creation of videos. But of course, AI has been with us for a very long time. Spam filters, recommendation systems on, let's say, Amazon, optical character recognition. This is all AI. Of course, now the powerful technologies of AI are now these very large models, often trillions of parameters that are able to do things that up until a couple of years ago, most people thought were not possible.
Thank you. The Pope refers in several occasions in his encyclical to accountability and transparency. Is AY transparent, accountable?
So another funny story. During COVID, I got an email from somebody in the computer science department, and she wrote to me and said, would you like to go in on a grant for designing accountable software systems? And I said, well, I would love to, participate, collaborate with the computer science department, but what's an accountable software system? And her response was, I thought you knew, you were the lawyer. And I would say that as a lawyer, I know enough to know that phrased in that way, it's kind of an unclear question. So let me break it down a bit. Okay, so when a computer scientist talks about accountability, what they mean is, are you able to identify the part of this AI tool, model, whatever, that is responsible for a certain result so that you can go back and fix it if it's broken? Now, one of the enormous problems and challenges of AI is that it's, so to speak, unexplainable. What do I mean by unexplainable? If you've ever looked at an AI model, like if you printed it out on paper, you would be shocked what it looks like. It's just a row of numbers. like really long numbers, page after page after page of numbers. And you have no idea what it means. The people who created it have no idea what it means. And if there's some problem, you don't know what numbers caused this problem. It's, so to speak, inscrutable. If you will, it's like some people think about supernatural entities, that they are not understandable by human reason. And so what's extremely interesting about AI, or I should say, the part of AI that is very popular now, which is generative AI. If you wanted to know, why did this thing happen, you would be hard pressed to be able to identify it happened because of this, which makes it extraordinarily difficult to figure out how to fix it or how to predict what's going to happen. So that's in terms of what a computer scientist would think. Well, what would a lawyer or a philosopher, an ethicist think? Well, you would think is, if you have this device that can do what we normally think humans can do, and it harms somebody, who pays? Now, obviously, the model's not going to pay, because the model is just a bunch of numbers. It's not alive. It's not even a moral agent. And so the question is, who is responsible in the sense of who is liable for damages that result, harms that result from AI? Is it the people who trained it? Is it the people who deployed it? Is it the people who used it for nefarious purposes? The problem with understanding the question of accountability is in part the fact that this is a technology which is unexplainable, but it also has to do with the fact that the technology was like invented like Tuesday, and it was just invented. And so none of us really know who should be holding the bill. And courts have been wrestling with this. There are numerous cases that are winding their way through different national courts. And what judges will be in the unenviable position of having to develop a new set of rules of accountability for this strange but powerful and exciting technology.
Well, you have talked about liability and accountability, but you have talked about liability, accountability, and you have started to make reflections on law and AI. AI. Chapter 4 of the Encyclica refers to a time of transformation of truth, work, and freedom. It is also AI transforming the law. Will lawyers or legal scholars still be needed, or we are going to disappear?
That's a very difficult question, and it's extremely important. So I'll tell you what I tell other people who say to me, Scott, you teach in a law school and you teach your students about AI and you like building AI tools for legal reasoning. Aren't you worried that you're going to put your students out of a job? And my first reaction is to say, you're under the impression that there's a glut of lawyers. In fact, there are no lawyers, at least in the United States, that will handle the bulk of the legal problems that citizens face. in the United States. That is, there is a yawning, enormous access to justice gap in the United States. And the promise of AI is that one of the promises of AI with respect to law is that we might be able to use this technology to bridge the access to justice gap so that the people who don't have lawyers can still get legal information, or to create new forms of collaboration whereby volunteers and lawyers who supervise them might be able to use AI programs in order to help those who can't afford fancy lawyers. The deeper question, I think, is, if you thought that what lawyers did was churn out paper, then I would be worried, right? Because AI churns out lots of paper. But those of us who've been in the legal profession know that that's not just what lawyers do. What lawyers do is they hold your hand. They explain the risks that you face. They say, I've been working for 20 years in this county, and I'll tell you how things work out. Let me speak to the prosecutor. I have a good relationship with the prosecutor. So those are things that, not anytime soon is is AI going to take over. That kind of acting in the old-fashioned sense of a counselor. Though, of course, people use ChatGPT and Claude for counsel and advice, and it does, in some sense, fill that role. But, and I want to just emphasize one last point before we go on, which is the thing about AI models, large language models like Claude and ChatGPT and various other of these chatbots. What they are optimized for is not truth. They are optimized for persuasion. They want to make it seem as though you got the right answer. And so the only way to distinguish the persuasive argument from the correct argument is to have critical skills. And that is still a place that lawyers play an invaluable role. And if I might add, because we are academics, it is in some sense our mission as academics to model critical thinking, model analytical behavior for our students so that they don't read the first thing that the chatbot responds and says, oh, I got the answer. So who knows what the future brings? Travel agents, big, who knows whether truck drivers or taxi drivers, whether they will have jobs in 5-10 years. But the types of things that I believe lawyers do is so human that I'm not terrified yet that my students won't have a job.
Yes, your students in the United States, but does AI affect in the same way to civil law systems or common law systems like the United States system, or are there any differences?
Yeah, so I think that's a great question because one of the things that I'm particularly passionate about is the idea that not all legal questions should be answered by the same technology. And in general, I think that chatbots like Claude, ChatGPT, Grok, Llama, DeepSeek, Kimi, you name it, they are particularly good, with an exception I'll mention in a second, they're particularly good in case-based reasoning. That is, they're very good about taking examples and inferring patterns from them because these AI models are pattern matchers. And so, insofar as case-based legal reasoning or common law reasoning is pattern matching, is trying to figure out the thread through lots of different kinds of cases, I think LLMs are very effective in that realm. Now, of course, they are not infallible or even excellent at it right now, in part because they hallucinate. But there's a second reason, which is that the vast majority of the high quality legal data that exists in the world is in private hands. They are on shared drives in law firms, in offices, all over the world, and they are not allowed to be shared. So the legal advice that Claude and ChatGPT and they got in part, not completely, but in part through scraping the websites of law firms and other things. How much deep knowledge are you going to get from that? Not much. But if you came from a system that believed that legal reasoning is not predominantly or even not even desirable that it be case-based, that the rule of law and fairness and equality requires that general rules be set out in advance in a code, in an orderly code, so you can go and look up the rule that you're going to be held accountable to. Well, then you don't want to use large language models because large language models are not particularly effective in applying rules. They're actually not good at all. You know what they don't do? There's experiments that we've done at Yale. They're terrible at saying not enough information. Why? Because the whole point of a large language model is it guesses. It's a great guesser. You don't have to tell it everything. It'll guess. The last thing you want to do in rule-based analysis is guess. What you want to do is you want to prod the user. Is this true? Is this true? Is this true? And you don't want any hallucinations, and you don't want pattern matching. You want logic. And here, I think there's very promising technology that allows rules to be reduced to some type of mathematical formalism and then have automated solvers, automated reasoners, theorem provers, call it what you want, derive the correct answer based on the rules and your circumstances. Now, if you think that everything is rules, then you're going to want that kind of technology. If you think that everything is case-based reasoning, then you're going to want LLMs. But the truth is, I can say this because I'm a philosopher. We're allowed to speak the truth. The the truth is that legal reasoning involves both aspects. And so legal AI and legal technology is going to have to adapt to the different forms of reasoning. And if a certain legal system claims that, well, we do this, but we don't do that, well, let's see. Let's see if you can get on just with these kinds of tools. My guess is that legal AI and legal technology will force people to be more explicit about the kinds of reasoning and the kinds of ways in which action and behavior is regulated in their particular legal system.
Thanks. Thanks, Scott. You have talked about how the EY is in a very little hands, very few hands of private companies. The Pope in the Encyclica talks about EY and the war, EY and the multilateralism, EY and the human rights. Which are the other ethic matters or questions that are affected by the EY, please? What do you think about it?
Yeah, so that's a great question and a very large question. So let me just begin by saying that when we talk about the ethical dilemmas posed by AI, I think we first have to just recognize a basic truth about tools. Any tool is dual use. This cup can be used to hold water for us to drink. I could also break it and then cut you. I won't. No, well, it's being recorded. And so any kind of tool can be used for good or for bad, okay? Especially a tool that's very powerful. And that is something that is very frightening. Such a powerful tool enables us to possibly cure cancer, bridge access to justice, enable us to never have to work again. But it can be used for deep fakes. It can be used to discriminate. It can be used to spread disinformation. So let me give you it's actually one example, but in some sense, two examples. And it happened last night. So the company that makes Claude is known as Anthropic. Anthropic produced a very sophisticated, very large model, which they were calling Mythos. And Mythos is apparently incredibly good at hacking, at finding security vulnerabilities. So what did they do? They did, I think, the very responsible thing, is they tried to mitigate the harm. How did they mitigate the harm? They decided not to release it, and they gave it to a bunch of companies under the name Project Glasswing, I believe it was Project Glasswing, so that they would have a head start and figure out what the holes that you can find through Mythos and patch it. So if you have a model that's so powerful that it can make all our digital systems insecure, well, that's scary, very scary. So Anthropic, I believe, did the right thing by mitigating, by not releasing it publicly. However, I had a lovely dinner last night. Got back late, looked at my computer. big announcement. Anthropic was releasing a guardrailed version of Mythos called Fable 5. Now, that means it was Mythos, but they put certain guardrails on, so you can't ask it, I want to hack, try to find a vulnerability. Or you can't say, I want to create a new virus. So they have all these things. And people have been complaining that it's clumsy because you can't even ask it anything having to do with biology or chemistry because it just says, I'm sorry, we're not going to deal with it. But that's not what caught my eye. What caught my eye was the price. Okay? The price. So about 5 months ago, don't quote me, the highest price model was about $2. It was GPT 5.4. I think it was roughly like $2.50 per 1 million tokens. And then Opus 4.7, then 4.8 came out, and it was a more sophisticated model, and it was $10. Now, like $10 for 1 million tokens is a lot of money. Trust me. I mean, they burn tokens like crazy, these models. So like $10. Okay, fine. Fable 5 is now $100 per 1 million tokens. So what does that mean? We've gone in 4 months to like $2.50 to $100. So that's what? That's like a 40-fold increase. And people think that even that is not representing the true price of using the model. So that means that who's going to be able to use this incredibly sophisticated technology, even that's guardrailed? If you guardrailed it so that terrorists can't use it, okay, that's great. But nobody else is going to be able to use it except for the very wealthy companies. So it's going to be super intelligence for you, but not for the rest of us. And that's extremely scary because that means that you've now created a tool that allows the wealthy to get so much more wealthy, and that the non-wealthy will not catch up. And so I believe that the Pope's encyclical, which, who am I to say, but I thought it was a wonderful document. I thought it was so intelligent and reasonable and deep and spiritual by pointing out the dangers of concentration of power and the worries about the inequality of wealth. I think this is something that I feel like I kind of saw it for the first time last night. And I fear that's the world we now are living in.
Thank you very much, Scott. Well, now we are going to move to the private international law. This is the section which is organizing this conference. So, Diego, Agulló, Professor Agulló, do you think that the Pope encyclical can be read from a private international law perspective?
Thank you so much, Professor Adroher. It's a true pleasure, right? It's a true pleasure to be here with Professor Scott Saphiro, dear Scott, with Salomé. And I want to thank so much academic Ana Fernández-Tresguerres for allowing us being here, right, together discussing this amazing topic. And now, I guess, yesterday in our dinner, Scott and I were discussing how complex private international law is, right? and Salomé and I know this very much, right? Also, Scott. So it's very complex, right? It's really complex, really technical. So I hope not to be so boring, right? Regarding private international law and the encyclical. But the short answer to your question, Salomé, is yes. Yes. And I would add something. Perhaps we must read the encyclical through the lens of private international law. Professor Paul Lagarde, in his general course of the Hague Academy of International Law, said that private international law should be understood in three inseparable dimensions: conflict of laws, applicable law, jurisdiction, and recognition and enforcement of foreign decisions. And in these three matters, everything is regards connecting factors. Of course, nowadays, private international law is more complex than this. Not everything is about connecting factors, right? But we still have a lot of analysis to do regarding conflict of laws, regarding jurisdiction, regarding recognition and enforcement, right? So reading the encyclical, I found something very interesting that I want to share with you. The word platform is cited 13 times in the encyclical. The word family is cited 19 times, including citations. But the word environment is cited 21 times in the encyclical. The word international is cited 28 times in the encyclical. But this is something very surprising. The word data is cited 36 times in the encyclical, right? And the word dignity, 105 times. Not only these words, but also governance, sustainability, supply chains, transnational corporations. This is what we do in private international law. The concepts we deal with in private international law. So, yes, I think we must analyze and we can analyze the encyclical through the lens of private international law.
Thank you. I thought the same thing that you when I read the encyclical. I found many questions related to our matter. You have talked about environment. Scott has talked about sustainability and accountability. In the encyclical, there are many many questions related to ECG. What can you say about that from the point of view of private international law, Diego?
In this case, right, the paragraph that was kind of inspiring to me, right, and surprising and nice at the same time, was paragraph 240, right? And please let me just quote it, because I think it's very interesting. 240, it says, the Pope says, I would encourage a careful examination of the supply chains of digital production, the working conditions hidden behind our devices, on the mechanisms that profit from manipulation and war. At the same time, practical ways of fostering fairness, participation, and care for creation must be found. There are two words here that are very important for me. I would encourage you, so the Pope is demanding, right? It does not use these many times, only another time where he encourages the church community. But here he encourages everyone, right? And it's the only time it says this word. And there is another important word in this paragraph: practical ways of fostering fairness. So all this should not remain only in the world of ideas. But we should put this in practice. And law is, among other things, for this, for putting all these ideas in practice. Right? So the encyclical talks about war, talks about sustainability, talks about ESG, right? Of course, sustainability and governance. But I want to share with you here and with the audience something that I think is making private international law bellicose, right? Fighting private international law, right? A new private international law. And that's the reflection I want to make right now, right, regarding this. 2 months ago, China has passed a new rule. It's called Decree 835 that says that if a Chinese company or a Chinese individual feels that has suffered damages out of the implementation of any due diligence directive or any sustainability regulation that comes from abroad, this individual can file a claim before Chinese courts against this company, right? So we may have regulations in the European Union like the Corporate Sustainability Directive, and I'm not going to refer to this one, just saying that it has an extraterritorial application because it requires European companies to control supply chains from the beginning till the end, and that means controlling supply chains abroad. We have very nice scholars that I like so much, like Professor Paco Zamora and others that has written extensively about this. But I want to refer what's going on against this. That's why I'm saying that we have now a bellicose private international law, right? Before we had conflicts of laws, right? But the conflict meant that you had a situation with different laws that conflict, and you have to decide which one applies. This is not true anymore. Now you have internal laws that go against foreign laws all the time. This is the new private international law that we are having. China is the second trade partner of the European Union, which is the first one, the United States, of course, right? What do we have in the United States right now, right? So we have an interesting piece of legislation that has been introduced at the end of 2025 that is called Protect USA. It has not been passed, but it contains private international law regulations. In particular, I want to just mention Article 5, Section 5B of this just piece of legislation. It's only a draft, right, that has been introduced. It says, and I quote, "No judgment by a foreign court brought against an entity integral to national interests of the United States." It's not saying an American entity. It's saying an entity that is integral to the national interests of the United States in relation to any foreign sustainability due diligence regulation shall be recognized in the courts of the United States or of the states unless otherwise provided by an act of Congress. What do we have more about this? We have sanctions, right? We are living in an era of sanctions. And you may say, well, that's public law. How does this affect private international law? It does, and a lot. And I will put just one example, right? To just try to prove my argument that private international law in the world is kind of becoming bellicose. It's kind of becoming strange, right? We are not used to this private international law. So, of course, the European Union has implemented sanctions against Russian entities for the war with the invasion of Ukraine, right? How does this affect to private adjudication? let me put you just an example of a case that happened just 2 months ago, right? It's a very recent case. All this case, everything that I'm saying is very, very recent, right? The Chinese regulation is from 2 months ago. This one is from also this year. So in this case, it's called Lavna Sea Trade Port against ThyssenKrupp and LNK. Of course, the Lavna port is a very, very important port harbor in Russia, in the Barents Sea, right? So ThyssenKrupp and LNK, Thyssen is a German company domiciled in Germany, and LNK is a Lithuanian company domiciled in Lithuania. So they provided materials, right, to the port, the Russian port. By the way, the Russian port is administered by a state-owned company, Lavna Sea Trade Port. What happened? That sanctions were implemented to the port by the European Union, right? And they took 8 million euros from the company, right? But this German and Lithuanian company could not provide the materials, right? I could not give back the 8 million euros neither, right? Because they were complying with the sanctions, restrictive measures, right? They call them restrictive measures, but they are sanctions. What happened? Surprisingly, there was an arbitration clause, and in the contract, right? And the port, the company, the Russian company initiated an arbitration where in Amsterdam, in the Netherlands, an ICC arbitration, because either give me my 8 million euros, either provide me with the materials, right? 3 arbitrators said that no damages could be awarded, right? Because sanctions were in place, and sanctions are a matter of public policy, very important in private international law. And as long as the arbitration tribunal is seated in Europe, the arbitration tribunal is also bounded by the sanctions. So you have an award, right? There is an award. What happens now? In private international law, we are used to deal with jurisdiction issues, which court has jurisdiction. We are used to deal with applicable law, right? And we are used to deal with recognition and enforcement. But here we have new things, right? Appearing out of this society that we are living in now. There are new proceedings in private international law that are non-recognition proceedings, right? So nobody is trying to recognize this award in Russia, but the losing party, together with the public prosecutor, asked a Russian court to say, do not recognize this award, right? It's not a recognition proceeding. It's just kind of something very strange that I had never seen before. That is just trying to having a Russian court saying that this award is not valid, like a non-recognition proceeding, right? Something new. But this is not very unique or rare. It's our daily life right now in international litigation. We are having anti-enforcement injunctions. So courts saying to a party, do not enforce this in another country. We are having anti-suit injunctions again. That was something very British, but now we are having American courts and Supreme Courts of some states issuing anti-suit injunctions right now. We are having anti-suit injunctions, right? So again, coming back to the practical ways of Pope Leo, and coming back to, he says, examination of the supply chains, right? Examining supply chains is very hard. Is very hard because of these private international law regulations that we are having. So I would say that private international law is more important than ever right now.
Thanks very much, Diego, for bringing so interesting new laws in China, in the United States, this decision in Amsterdam. You have talked at the beginning of different words that appear in the encyclical very frequently. One of these words is data. What do you think about data protection from the private international law perspective? What do the Pope Leo says in his encyclical that
Yeah.
can we bring here to finish this session
Yeah.
and give the floor to all the assistants?
Yes. Well, there is another paragraph that I found very interesting because it's not something the encyclical is not something that you have to interpret. It's kind of very clear, right? It's kind of strong words, right? You don't need to interpret something. No, it's clear, right? It says in paragraph 178, and I quote, "These have become the new rare earth of power," and it says, "vital data, which, once aggregated and analyzed, can be used to train predictive models, guide investment strategies, anticipate crises, and above all, determine who and what is deemed to matter." How strong is this? Right? And I want to connect this part about data. That this data is very cited all along the encyclical with what Scott has said about accountability and how hard it is to monitor what's going on in an AI tool, right? And to see how is the decision-making process, right? Because we have in the Court of Justice of the European Union two very, I would say, vital, important decisions, right? That may us make think a bit, right? They deal with Article 22 of the GDPR, right? I'm not going to address, the private international law aspects of the GDPR. There are many, many nice writings about this. But I think that these two cases have not been analyzed in the sense I will do it now, right? There is Schufa case and Dan and Bro. The court held that the generation of a credit score, right, in an automated decision, where a third party draws heavily on it, an investor, right, the responsibility of all this decision making falls both within the agency that has been made this score credit score and the bank or the financial institution. So what's this, right? In plain words, we all have a credit score, right? So I remember once that I went to buy a technological tool, right? In the famous El Corte Inglés. Scott, you should visit this, right? Because it's kind of very important here. And they said, no, we cannot give you a credit to buy, I think it was an iPhone, I don't remember, because you have a debt and your credit score is horrible, so we cannot. And they say, oh my God, I don't have any debt, right? I had, of course, and this is very important in the US, I know that, right? Here is less important, but it's still important. Of course, it was not me, I solved it, but see how problematic it is to have a bad credit score, right? Meaning, if you are a good payer, right? So there are agencies that do these credit scores in an automated way. I think in this case, not yet AI, right? But I think they are doing it with AI right now, right? So it may happen right now that your CV, right, will be accepted to have an interview in a recruitment proceeding just because the AI has said yes or no, or your credit score, or many other things regarding your data and your rights will be analyzed only by an AI tool. Well, in this case, the Court of Justice of the European Union says responsibility. We talk about responsibility. Both of them, the agency and the investor or the bank or whoever has to give you the money. But we have 2025 decision, the Dun and Bradstreet decision, that confirms something, a right to an explanation, right? Having an explanation of how this information, right, has been treated, right? And, you know, if you were given that credit score or not, why it was given, right? According to which proceedings, right? What's the problem with you that you have a very low credit score, right? So what happens when AI, right, is not accountable? You cannot trace anything. And AI is used to just maybe hire you or not hire you, or give you a great score, or whatever, right? It's very hard. So I think we will face like many challenges regarding accountability. And I agree with His Holiness, right? These are the new rare earths that are vital data. For what? He says so. For investment strategies. He says that in the encyclical, right? So, I mean, my point here is that the law in general and private international law is getting more and more and more complex. And we have a lot of private international law challenges and problems to study and try to solve in the coming years, for sure.
Thank you. Thank you very much. Thank you very much, Diego. Really interesting. There are earths, our data. Well, we are more or less on time. So please, I give the floor to the assistants who want to make any question or pose any question to Scott or to Diego. The floor is yours. Yes, Monserrat.
I'm an analogic person. I want to make it clear, but it's fantastic. Let me ask. When I went to become los decoración de las vacías, there was someone who just gave me beautiful touch, what you have done, what you have done today. And the thing I always hear is, what is going to happen with all these things you have just put on the table, no? The responsibilities, not the physical or economical and moral, in any way of responsibility. And you have said, who makes the law of the AI, or who just offers it, or who just uses it. I find it's a terrible question. I feel very afraid, let's say. And another thing is there is a international law, no? A public international law and a private international law. And then inside this, the personal or the public international law, which is very important and with a very important consequences. Very important for the family, for the children, for the let's say marriage or everything. And what I have not entered to use, I've never used the AI, but is there something, or do you think is there any of you of the board of you? Is there some things you just feel it's going to be all right, or it's going to be terrible, all right? It's going to be in this kind of things more personal, no? With this private, inside the private international law, because there is especially in the cases of when you just get different public authors, yeah, different public authors, different that, so we have, you know, several things, especially, let's say, the mixed matrimonial law of the same sex person, or the, let's say, the laws of marriage in the, let's say, the Arab countries, and all these things, how this AI is going to make it, you know, his way through these terrible things.
Thank you. Thank you very much, Montserrat. I'm going to explain to the online assistants to resume what you have asked, I think both to Scott and to Diego. No? Perhaps the question to Scott is, who is responsible for the AI? You have talked about it, but perhaps this is the first question. And then what happens with the private life, especially the family life in private international law with the AI? Please, Scott.
So let's go through the possibilities. Okay. So at the highest level, you could have countries get together, and Microsoft was trying to arrange this a couple of years ago, get companies together and regulate it through a treaty, through public international law. Huge mistake. You do not want to do that. Why? Not because international law doesn't matter. I believe it's enormously important. It's just not, well, to use the, Pope Leo's invocation of subsidiarity, it's not the right level to address it. It's too high of a level. It's not close enough to the lived experiences of people. Also, it is international law is notoriously difficult to enforce. And so what my colleague Ona Hathaway has shown with respect to human rights, that, the biggest human rights abusers sign on to human rights documents because they have no intention of abiding by it, whereas liberal democracies that care about the rule of law are not sure they want to touch it because, well, if they sign it, they're going to have to abide by it. Okay, so I just think that that's a mistake. So then, should we be doing this at the national level? Well, again, it depends on the system. I'll just talk about in the United States. There are basic things that the Biden administration was trying to do, and I participated in this project, which was to at least identify the effects that AI technologies could have in particular use cases. That is, identify whether they were safety impacting or rights impacting. And so that's very helpful to know these are the possibilities. You might not know that these were the risks associated with some of the technologies. Very sensible, but not lots of teeth. So then, should we have states regulating it? States, that is, in the United States conception, that is subnational. Well, do we want, basically, it will be California that determines what the law of AI is in the United States. So it's not gonna be a ground up regulation. So that really suggests, to me at least, and there have been very kind of ham-fisted attempts to deal with regulation at national levels. So, for example, there's the EU AI Act, which I think has, I think when you talk to companies, they have no idea how to comply with it. They don't even know, like, because it was written, I mean, it was written really before people figured out how to use it. So it was a mistake, I think, to be that far out ahead of practice. The Trump administration has wanted, and I don't think this is an unreasonable thing, that they want, if there's a new model that's come out that has serious national security implications, maybe either they get a look at it first, or that it gets embargoed, it gets shared some way. Again, sensible. I think it's more sensible than what the Biden administration did. Biden administration said, every time you train a frontier model, they want to see it and test it. What? These things come out like every day, right? They're changing like all the time. What are you gonna like get? It's like, here's, before we roll out GPT 5.6, please, government bureaucrats, look at it. I mean, what are they gonna know? So then it really comes down to courts. And so, should we regulate AI through civil liability? Well, as we all know, there are so many different possibilities. There's strict liability. If somebody is harmed, it doesn't matter whose fault it was. The one who produced it has to bear the cost. Well, maybe that's going to stifle innovation. So maybe we should have negligence. What would a reasonable person do under the circumstances? Well, indeed, I ask you, what would a reasonable AI designer do under the circumstances? Who knows? I mean, who knows what any of this means? Okay. Some people think that no, what we should do is not have any kind of civil regulation, because what will happen is that the market will punish companies for being irresponsible. And I think to some extent, I think that's been true with respect to XAI's model Grok, which I think XAI has acted in an irresponsible fashion, not having guardrails for various types of new deep fakes, nudification of non-consenting, almost always women, and perhaps, in some cases, minors. So that's, it's possible that the market is punishing Grok for that kind of behavior. There are lots of possibilities, and it's good for law professors because it's a full employment act for us. Okay. So I'm sorry I didn't answer your question. I just wanted to lay out a lot of the possibilities and why it's so complex. Yes, yeah, especially San Diego. Yes, it's wonderful weather. Although I love the weather here too.
Yes, regarding families and families in private national law, the encyclical talks about families a lot and about displacement of families a lot, right? There is also a principle that, for me, that I'm not a canonist and either I'm not a theologist, right? But for me, it was very important, right? That because it's mentioned a lot of times, it's the principle of subsidiarity. It says that everything that can be managed at the local level among families, associations, should not be managed by the state. But here's the point. Should not be managed only by the companies either, that are kind of the new powerful, right? New powerful states or elements here, right? So that kind of aligned with what Scott has said about international treaties with this hard, right, to implement and to get this agreement. So I agree with this principle of subsidiarity, right? Not trying to elevate something so much, right? But going more practical on living the principles and all this, AI for family law, for international family law, it may be an opportunity, right? Because now you can ask how every law of the world is regulated or performs or says about something. Of course, there are mistakes. Of course, there are hallucinations. But before, it was impossible to know. Either you were a lawyer that was a specialist in private international law, even in this situation, how do you know if you have, and Salomé knows much more about this, if you have a marriage, right, when one of the spouses is from another nationality and you want to apply to your kind of capitulaciones, right, your contract of foreign law, now you can know how foreign law reacts to a given situation. And that's amazing, right? That's something amazing. And you can ask many things. Of course, we have many problems, many hallucinations, of course, but there it is. And I think that you can, we have to deal with this, right? And I prefer to just opt for being, I would say, I don't know, just to accept it, right? Try to be as happy as you can and use it every day, right? And try to know how it works and improve and include it in your research, in your teaching, and so on and so forth, right? Another element here important are minors, right? Minors and children. So children are mentioned a lot as well in the encyclical. We have to take care of them, and Scott has talked about this, about safeguards and about how what happens with these AI tools that are not as good as we want, and minors are vulnerable here, and we should protect them. And the Pope also addresses this element. Oh, sorry. Yeah. Yeah.
Just started this path.
Yeah.
And he is following.
Yeah.
He's following that.
Yeah.
What you can study them.
Yeah. Yeah.
Not yet,
Yeah.
but how was the path, the Pope, this Pope, our Pope today? It just because they spoke in TV or here in circles about the reality and the idea. It's not something that comes from their own. It comes because there are two books, very good ones,
Yeah.
from 2024 and 2035. Two books. I have studied them and I have written about them. And that is something about Francisco just left. The reality above, of superiority to the idea. And he asked, let's say, Senan, and she's a philosopher and theological, she has studied both of them, and to make, a study of the C9, of the, let's say, the cardinals, this little group that just support and help the Pope and the C9, and this, they studied three people, and then two cardinals answered to this question in these books, because they were published in the books afterwards, and the Pope cites it, Francisco. And the thing is, reality against the idea. The reality actually is so different that the old idea, the church or the popes are in this Humanitas and this Ética, and they are so different. And I have seen that both the last two popes, Francisco and Yale, they want to accept that reality, the actual reality, the reality today of the church. The subject was the subject of these two books were how was the let's say the work and the place That was
Yeah.
best. But nowadays, this synodality that we are following, even taking, let's say, power to the Julia and giving power to the laicos, no? And what does he says in this Encíclica? What does he say about this reality and idea following the idea of Francisco of just putting down the idea, the old idea of the church, and giving let's say, and giving the reality, the place it needs to have today in the church?
Yes, I'm not a theologist, neither an analyst of encyclicals, but I'm very happy to speak about the encyclical because it addresses everyone. It is not a document for theologists only. It is for us as well. So it's for us, it's for everyone. He addresses everyone. So I feel so compelled to refer to whatever he says in the encyclical. And he cites a lot Pope Francis, a lot Laudatio Si, a lot. But he also cites Rerum Novarum from Pope 13, a lot. A lot. And the problems that happened in Rerum Novarum in the Industrial Revolution are similar. There is a change, of course. The situation has changed. The popes are different. Of course, before they were all Italian. Of course, they're different. We have an American pope. Of course, it's different. But the pope dedicates 2 chapters, 2 entire chapters, to analyze other encyclicals, to analyze writings, and does not get to AI until the 3rd chapter. And I think that in essence, the church has been evolving and adapting to reality every time. Also, if you read Rerum Novarum, it's innovative. The things that are said, of course, other things, I read it just to see why you see some things that you wouldn't say today, of course, right? Of course. But others were so innovative. In Rerum Novarum, Pope Leo XIII talks about rights, about salary, about decent work. So I may agree with you, it's a continuation of Pope Francis, but he refers to other encyclicals, very, very old encyclicals, and Rerum Novarum is from the 19th century.
Thank you very much, Diego. I don't know if there's any other question between people who have come in the... Or si tenemos online alguna pregunta.
No, I have a question.
Yes.
I have a question for Scott. You spoke about the counselor role for lawyers in the old-fashioned sense of the word. You mentioned holding a client's hand or doing that.
I mean, in a way, like the role that a lawyer, especially a powerful lawyer, plays in transactional work is immense. I mean, they are networkers. They connect. I mean, like if you have a startup, let's say, and you're a lawyer, like the lawyer will connect you with other of their clients that they know. And they have a network of people. You go to, if you're a big company, you go to one of the big firms that maybe you've worked with before because you trust them, because they're efficient, because they don't lie to you, because you like the fact they're from Texas. Who knows why? But lawyers play an enormous role in transactional work. I mean, just think of basic things like when you get if you buy a house, Like, how do you pick your real estate attorney? You ask a friend. You say, like, who's your real estate attorney? Did you like them? And so that kind of human connection, networking, trust, reliability, efficiency, authenticity, and honesty, I think, are really, really important when it comes to business transactions, not just in terms of litigation.
Thank you very much. And in family law, of course.
Oh, well, of course.
Of course.
Yeah, absolutely.
Thank you.
But that's,
That's
I mean, yeah, that, right, that's in some sense like the ultimate like therapist. Yeah,
Yeah,
yeah.
really.
Yeah.
Thank you very much, Scott. If there's no any other question, perhaps we could close this session. Thanks very much. Congratulations, Scott and Diego. I think we can give applause to them. And thank you very much to all of you because of your presence here in Real Academia de Jurisprudencia y Legislación. Muy buenas tardes a todos.
Gracias.